Well, good afternoon, everyone. It's a pleasure to have you all in this Old Square Tax Chambers webinar about changes to pensions taxation. Um, uh, I'm not sure how to start the video, I'm afraid, because that's something for the host, it seems to do. But hopefully that will be done in a second. In any event, I'm joined this lunchtime by Rebecca Sheldon, also of Old Square Tax Chambers. We will be giving first a talk by Rebecca, outlining some general points about pensions taxation, and in particular unauthorized payments out of pension schemes. And then I'll be talking about changes in particular to the rules on pension commencement lump sums. First, housekeeping, of course. If a fire alarm goes off in the course of this webinar, I'm afraid I can't really help you. You're on your own with that. But hopefully none of you will suffer that in the course of the next hour. Apart from that, this is being recorded. So if you happen to miss any of it, or if any colleagues want to see it, that will be available, I suspect, later on this afternoon. With that introduction, then over to Rebecca.
My video also isn't working, which is deeply disappointing because I put on a shirt especially to give this presentation. So alas, you'll just have to cope with my slides, which Noah, I think, is going to get on the screen in a second.
I will do apologize for the video. I'm in a bit of trouble here, but I will get the slides on right now. Just bear with me one moment.
The slides are a lot more important than my face, don't worry. Yes, great. Yeah, I can see them, so I would assume everybody else can.
Yes, Rebecca, your slides are up, Rebecca.
Perfect. All right. Yes. So as Philip has said, this is a talk about pensions, and what I'm going to do, which hopefully will be of use to some of you, maybe a little bit boring for others, is set out the context in terms of legislation and in terms of where there are particularly interesting points in the case law. And then, as Philip says, he's going to look at where there are some changes. So yes. So moving then to the next slide. Yeah, so we're going to be looking at payments made from registered pension schemes, which are alleged to be unauthorised payments in particular. And this is in the context of payments made within the UK by UK registered pension schemes. I'm specifically going to look at the legislative framework, although I'm not going to read it out because that's incredibly boring. The meaning of authorised payments, the meaning of unauthorised payments, the meaning of payments, and then the case law concerning the so-called pension liberation schemes, one of which I was instructed on. Then going to look at the various charges and who's liable for them, as well as the meaning of and the application process for a good faith discharge. So if you move now to the next slide. Yes, so as I'm sure all of you know, the legislation primarily can be found in Finance Act 2004 and in ITEPA 2003. And I'm going to start by looking at the meaning of an authorised payment, because if you are authorised, then of course you're not unauthorised, so it saves you a bit of time. The definition is therefore also very important. So there are certain changes to the relevant definitions as a result of the abolition of the lifetime allowance and the introduction of the lump sum allowance and the lump sum and death benefit allowance following FA 2004. And that's going to come into effect on the 6th of April 2024. So of course is in effect now. Philip is going to talk to you about this in more detail, so I'm not going to step on on his toes, but I'm just going to draw your attention to where the changes have been made in the relevant definitions. So in section 164, we've got changes to subsection 4. Again, we're talking now about the lump sum allowance and the lump sum and death benefit allowance. And we've also got changes to section 166, which is the lump sum rule, where we've got the pension commencement excess lump sum has come in, and the removal of the lifetime allowance excess sum and various sections surrounding that. Now, FA 2004 divides the payments into authorised employer payments and separate payments, employee payments. And so section 175 deals with authorised employer payments. And these are the only payments which a registered pension scheme, there's an occupational pension scheme, is authorised to make to in respect of a person who is or has been a sponsoring employer. And these are set out between sections 176 to 180. And I'm not going to read those out, but they include things like public service scheme payments and authorised employer loans. And again, I'm not going to read it out because that's very boring, but that's where you find them. So we also have, I can find where it is in my notes, authorised member payments. And although I drew your attention to them at the start just to set the context, these are in contrast to the employer payments, which have a separate definition, and you can find the main definition of that in section 164. So moving to the next slide, if my clerk hasn't died of boredom, we are now looking at the meaning of unauthorised payments, which is a lot more exciting. And this starts in section 160 FA 2004, and it deals with payments made by registered pension schemes. So the only payments which a registered pension scheme is authorised to make to in respect of a person who is or has been a member of the pension scheme are those in 164. And in this part, an authorised member payment means a payment which is not authorised by 164, or anything which is to be treated as an unauthorised payment to in respect of a person who is or has been a member of the pension scheme under this part. So where are we? So broadly then, if a payment doesn't come within the definitions above, it's going to be an unauthorised payment. And there are, as implied by the delineation that I've just gone through, two different types. So there's an unauthorised member payment, where a payment is made by a registered pension scheme to in respect of a person who is or has been a member of the pension scheme, or where it's deemed to be an unauthorised payment. And there's going to be unauthorised employer payments, where a payment is made by a registered pension scheme, is an occupational scheme, to in respect of the person who is or has been a sponsoring employer. Now, there are certain types of payments which are set out in legislation as being expressly unauthorised. And again, this is a helpful shorthand. I'm not going to go through all of it because, again, it's very dull and I'm sure you all know about it anyway. But between sections 172 to section 174A, you've got a list of things that are expressly unauthorised. So things like assignment and surrender, and increase in the rights of connected persons on death. So where do we get to in the case law? Where have issues arisen? So moving to the next slide, what is a payment? Now, I might think this is a very simple question, but the courts have actually grappled with it numerous times. And section 161 is the starting point, which sets out the meaning of a payment in the legislation. And subsection 2 helpfully says a payment includes the transfer of assets and any other transfer of money's worth. Now, the Court of Appeal in Clark and HMRC considered the meaning of payment within the meaning of an unauthorised member payment. And paragraph 1 summarised the relevant issues. So I'm just going to run through that. So the appeal involved two distinct questions of principle. The first issue was whether the meaning of the word payment and the consequential charges of tax in respect to such payments contained in section 208 to 210 was met. And the question was whether the word payment construed in its statutory context was apt to include the transfer of money from one registered pension scheme to another in circumstances where it later transpired that the trusts of the recipient scheme were void for uncertainty. The agreed consequence of the transfer is that the transfer was in law effective to transfer only bare legal title, and the beneficial interest was held on resulting trust for the transferor. So was there a payment? It was held, paragraph 82, that in their view, the clear purpose of the provisions in FA 2004 and Part 4 is to impose a charge of tax at a high rate, depending on the amount of the fund used up. It's either 40% or 55%, in respect of unauthorised payments as defined, whether the payment in question is an unauthorised member payment or an unauthorised employer payment, and whether or not a breach of the scheme rules or a breach of trust is involved. In most cases, there'll probably be such a breach, but that's not an essential feature of the charge. Rather, it's the responsibility of scheme trustees and administrators, as well as of scheme members and sponsoring employers, to ensure that payments which are made out of the fund to and respective members or employers fall within one of the authorised categories. If they do, no tax will be chargeable, but if they don't, tax will be chargeable under sections 207 to 209. So the question whether a payment is made for these purposes should be answered by looking at the practical business reality of the transaction, which is sort of hinting at the conclusion that we get to, including any composite transaction of which the payment forms part. If the intended purpose and effect of the transactions is that money leaves the scheme and is placed at the free disposal of the member, the mere fact that the money may be subject to an equitable obligation to restore it to the scheme will not prevent it from being a payment in the ordinary sense of that word. To conclude otherwise would deprive the charge of tax effect in many of the most egregious cases where it was most needed. So here, even though we didn't read, so the only bare title to the payment was transferred, we still had a payment for the purposes of the charge. Another case which has looked at this issue is Morgan Lloyd, and here the FTT held that the payment didn't include any amount of VAT on the purchase price of an asset that was recoverable as input tax by the trustees. I am told that HMRC haven't indicated that they're going to appeal this. It's also been said that payment includes book entries where the amount still outstanding under a previous loan was consolidated with a new loan, even though no new money was being advanced in relation to the old loan. So we've looked at the meaning of payment, and as you can see, it is quite broad. If we then move to the next slide, I'm going to look at some case law examples of pension liberation schemes. Yeah, so that one. Thank you, Noah. So the first of these cases is Dalriada. Now, this was a case that I was instructed on, and I appeared for one of the members in an extremely long hearing. It was 10 days in the FTT a couple of years ago. And here, the appellants appealed against tax charges imposed by HMRC in relation to unauthorised payments made under a pension reciprocation plan. Now, for those who don't know what that is, in effect, the plan was that you had two different pension schemes making reciprocal loans of funds to members of each other's schemes. And the idea was that that would somehow fall outside the rules. I'm sure it will surprise no one that this was held to be an unauthorised payment. And another case which was dealing with a pension liberation scheme is Danvers and HMRC. Now this was where a pension scheme member appealed against an FTT decision that HMRC had been entitled to treat a loan as an unauthorised member payment. So just to cover off some of the facts, at the age of 41, pension scheme member had wanted to access part of his pension fund without incurring income tax, shock. And to that end, he became a member of a registered self-invested personal pension scheme to which he transfers his existing pension funds of around 35k. He then instructed H, which was the registered self-invested personal pension scheme, quite a mouthful, to invest the funds by purchasing preference shares in a wholesale lending company. And then based on that investment, a further company agreed to loan him around 18k. The loan was advanced on an interest-only basis, and the capital was to be repaid from the net proceeds of the member's pension. Now, HMRC decided the loan was an unauthorised member payment and was subject to an income tax charge and a surcharge under 208 and 209 respectively. Right, so now we've hinted at looking at unauthorised payments. If we move to the next slide. So again, I'm not going to read out all the legislation, but I'm just going to signpost through it so everyone knows where to look. So section 208 sets out an unauthorised payment charge as follows. So it's a charge to income tax where an unauthorised payment is made, and the person liable to charge in the case of an unauthorised member payment is that person. So the person liable, if it's a member payment, is the member. And in the case of an unauthorised member payment made in respect of a person after the person's death, it's the recipient. And if it's an employer, is the person to or in respect of whom the payment is made. And this does actually come up quite a bit in practice. I've had instructions recently looking at a pension scheme to determine who was liable for this charge, and sort of attempts to move that liability. So this is quite important. And then section 209 looks at unauthorized payment surcharges, and this is a charge to income tax arises where a surchargeable unauthorized payment is made by a registered pension scheme. And the section of this is section 209. Again, the person liable to the charge in the case of a member is that person. If it's to a person after that person's death, it's the recipient. And if it's an employer payment, again, it's in respect of whom the payment was made. So we then move to section 210, which sets out that surcharge but unauthorized member payments are defined as, and again, I don't want to read it out, so I'm just going to summarize it. A very complex, well, I say a very complex formula for me in subsection 9, which I am not going to read out, but UMP is the amount of authorised payments and VR is the amount equal to the aggregate of the value of the member's rights under arrangements relating to the member. And you have UMP over VR and you times 100, which sounds awful. Section 213 then sets out the definition of a surchargeable unauthorised employer payment. Instead of V, we have AA, and AA is the amount equal to the aggregate of the amount of sums and the market value of the assets held for the purposes of the pension scheme at the time when the unauthorised employer payment is made. And then section 239 sets out the scheme sanction charge. And again, I've had instructions recently trying to move this. So this is a charge to income tax where in any tax year, one or more scheme chargeable payments are made by a registered pension scheme. And the person liable to the scheme sanction charge, in the absence of anything else which shifts it, is the scheme administrator. So what can we do about the unauthorised payment surcharge and the scheme sanction charge? Well, moving to the next slide, we can look at a good faith discharge. And this starts with looking at section 268. And this applies where a person is liable. The person liable can apply to the Inland Revenue, i.e. HMRC, for the discharge of the person's liability to the unauthorised payment surcharge if the ground in subsection 3 is met. And the ground is that in all the circumstances of the case, it would not be just and reasonable for the person to be liable to the unauthorised payment surcharge in respect of payment. And the key words there are, it would not be just and reasonable. Now, on receiving an application by a person, HMRC has to decide whether to discharge that person's liability to the unauthorised payment surcharge in respect of the payment. And the scheme administrator can also do the same thing. The Inland Revenue, again, HMRC must notify the applicant of the decision. And if we don't get anywhere with HMRC, what do we do? Well, we look at section 269, and there are, again, some consequential changes under Finance Act 2024, which are now in force, which Philip, again, is going to be looking at in more detail. But it's just... oh no, actually, I think I'll look at this news because I don't think Philip is covering this bit. That's good. I'll do that. Okay, so there's appeal against the decision on a discharge of liability, and they've removed all the references to a lifetime allowance charge. That's the bit Philip's doing, but they've also changed the wording in terms of when the tribunal has to grant the application. So rather than it saying rather than it, I mean, there's nothing really of substance. I mean, it in effect just says that they will grant the application if the tribunal considers that the ground is met, rather than having several sections leading up to that, setting out things about the lifetime allowance charge and setting out things about whether the applicant's liability ought not to have been discharged. So it's in effect the same, it's just slightly different. Nothing to worry about there. Now, how do we make a good faith discharge application? Under section 2683, there are 3 requirements, which I know in detail because I had to argue this point pretty hard in Dariada. And these are set out in helpfully in regulations. So it's paragraph 3 of SI 3452, registered pension schemes discharge liabilities under sections 267 and 268 of the FA 2004, regulations 2005, which you'll be pleased to know I'm now just going to call the regulations. And this says, and has 3 criteria, as I've said, any section 267 application or section 268 application must be made in writing. In the case of any other applicant, so here members, etc., no later than 5 years after the 31st January next following the year of assessment to which it relates. And a section 267 application or 268 applications shall set out particulars of the ground relied on under the relevant section. So what does that mean in practice? Well, HMRC and Bella is the main test, and it's an upper tier case, so binding, and it was held as follows at paragraph 70 onwards. So as the consideration should be taken into account in evaluating the question whether it's just and reasonable, we would respectfully endorse what was said in O'Mara. So if you're looking at this, it's always helpful to go back to O'Mara and look what was said there as well. Moving back to Bella, the statutory test will not benefit from unnecessary gloss. It requires the tribunal to examine all the circumstances and decide whether it be just and reasonable for the appellant to be liable to the surcharge. It does not require any finding of dishonesty or negligence on part of the appellant. It allows the tribunal to examine all the circumstances surrounding the making and receipt of the unauthorised payments in each appellant's case. This in turn allows the tribunal to examine an appellant's conduct or any other relevant mitigating circumstances pertaining to the payments or the appellant's circumstances. And it also allows the tribunal to take account of the statutory scheme and mischief the surcharge is designed to prevent. We detect that there has been some difficulty in formulating precisely what the nature of the statutory scheme is, having rightly acknowledged an important point, namely that the aggregate of the 3 charges that HMRC can impose is either 70% or 95%. Tribunals have gone on to consider why that is the case. And in some cases, they have posed the question whether the charges are penal or intended simply to recover tax reliefs and exemptions previously given. We do not ourselves consider that whether the charges are described as penal or not will serve as much as a guide, in particular as to whether it is just and reasonable. And what we need to do is consider the entire statutory scheme of which these charges form part. While conceptually it might be said that tax relief granted to individuals and employers at certain stages is counteracted by the taxability of pension benefits at later stages, the overall scheme clearly involves material cost to the Exchequer. Now, Parliament is content for the Exchequer to suffer these costs given the social utility of individuals saving for their retirement, but only where the entire bargain is respected. And it's for this reason that different aspects of the unauthorised payments regime applies. And then it gives some examples. So if a registered scheme impermissibly pays benefits to a member before they are 55, there's an unauthorised payment because the Exchequer suffered costs outlined, where since the funds have been drawn before retirement age, the social utility of funding retirement is not present. And in a similar vein, if pension funds are lent by way of risky loans to an employer, the Exchequer is exposed to the risk that even though it is given tax relief and exempted income and gains on the scheme from tax, the funds are not ultimately available to pay pension benefits. So these observations also explain how the making of an unauthorised payment can be more or less serious, and this is important. So, for example, an extreme form of pensions liberation might involve a coordinated attempt by an individual to access a pension fund in a registered scheme before they're 55 in a manner that escapes tax altogether. Such a scheme would impose on the Exchequer the cost of deductions at several stages, even though no retirement benefits are provided. And considerably less serious would be the making of a loan to an employer which, whilst it fails the requirements necessary to be an authorised employer loan in the sections that I referred you to earlier, it's ultimately repaid in full with a market rate of interest so that the Exchequer suffers no actual cost and the social utility of the provision of retirement benefits is preserved. So how did this play out in my case? Well, in Dariada, the following was held with regards to the member application for good faith discharge. So she had not made a valid application for the discharge of the unauthorised payment surcharge in respect of the tax year 2010-11 within the applicable time limit, which was really unfortunate because they would have actually given her the good faith discharge. So They held that she knew that there were rules designed to early access to pension monies, but had chosen to proceed without taking any independent advice. However, in terms of the levels of seriousness of unauthorised payments as set out in Bella, her case was at the less egregious end. So she intended to discharge in full the loans that she had drawn down, and she had not received an outright payment of any kind. And furthermore, when she chose to become a participant in the pension reciprocation scheme, she was desperate to find a means of raising money. She was in significant financial difficulty. And her view that the PRP would not give rise to unauthorised payments was genuinely held, and it was a reasonable conclusion for a layperson to draw. And the FTT felt that she had suffered enough by virtue of her decision to participate in the PRP without also facing the additional cost of the surcharge. So had she met those three conditions that I went through, in particular, that it was, well, it was in writing, but the issue was that there was simply a bald sentence saying, we would like a good faith discharge. And the third requirement is that you need to provide grounds. And I tried to argue that it was implied from that sentence that the ground was set out, because impliedly you could say that they were setting out that they must therefore think it wasn't just and reasonable. Unsurprisingly, I think the judge held that was not correct. So unfortunately, even though the court would have gone and granted the good faith discharge, they were unable to because of the way the scheme is set out. So it's really important to make sure that you're meeting the statutory requirements. So looking then at a final couple of cases, because I think I've only got a couple of minutes left, I'll hand over to Philip. You'll be delighted to know. In Curtis, as the taxpayer had been the victim of a scam, it was held that it would not be just and reasonable in all the circumstances for them to be liable to the surcharge. And this sort of chimes with what happened in Dawiada, because where there is some element of someone being taken advantage of and relying on other people, it's going to be a lot easier to say that it's not just and reasonable in the circumstances for this extra charge, because don't forget, you've still got the other charges that still apply. And in O'Mara, the FTT commented that the burden obviously was on the appellant to satisfy the tribunal, and it did not require any finding of dishonesty or negligence. And I've just gone through that in Bella, so I won't bore you further. So I think that's pretty much set out the broad background behind pensions and unauthorised payments. I'm now going to hand over to Philip, who is going to look in more detail at some of the recent changes. Thank you for listening.
Thank you very much for that, Rebecca. Let me just share my screen. I can find the right, there we are. There, and hopefully everyone's able to see that. The screen tells me I am screen sharing, so I'll assume that what my PowerPoint is up on it for everyone, not just me. So thank you, Rebecca, for that very interesting talk about authorised and unauthorised payments, and in particular very important provisions in sections 268 and 269 of Finance Act 2004, which unusually, when everything has gone wrong, allows HMRC or the tribunal to grant relief from charges, or certain charges, broadly if it's fair and equitable for that to be done. Hopefully something that we'll never need, but inevitably occasionally one has to resort to those. So I'm going to talk about changes made by Finance Act 2024 to the rules on pension commencement lump sums. The big picture points going forward, there will be two types of pension commencement lump sum: the pension commencement lump sum itself. If something counts as that, then it is an authorised payment, and it is exempt from income tax. Second type, pension commencement excess lump sum. If something counts as that, it is likewise an authorised payment, but it is subject to income tax, just as any other pension income is. In working these things out, one has to be very careful for clients who have pensions also in overseas pension schemes, because of some infelicities in how these rules work in that context. And of course, I'm just talking about the new provisions. The nature of pensions means that the extensive transitional provisions which are included in Finance Act 2024 will require to be considered for doubtless decades to come, or at least until the next substantial overhaul of the pensions regime. So, pension commencement lump sums defined in Schedule 29 FA04. There are changes to the definition. We have a new Chapter 15A of ITIPA 03, which sets out in short the way that all sorts of lump sums provided by pension schemes are to be taxed. I'm not going to look at ill health lump sums, trivial commutation lump sums, small pot lump sums, that sort of thing. I'm only focusing on pension commencement lump sums and excess lump sums in this talk. I'll look at the provisions against overseas pensions, and as I mentioned, the new regime recognises two different types of pension commencement lump sums. Turning to the first type, the conditions for something to count as a PCLS are set out in paragraph 1 of that schedule. First, a member must be entitled to it in connection with becoming entitled to a relevant pension. So in other words, it has to be connected to the start of an actual income, a pension income payment, or at least pension income entitlement. One important point that I'll look at in a bit more detail, it has to be paid when all or part of a member's lump sum allowance and lump sum death benefit allowance are available. Now, these are the allowances that replace the lifetime allowance, and the new provisions for those I'll come back to. They must be paid within the period starting 6 months before and ending 1 year after the individual becomes entitled to it. So once someone's entitled to a PCLS, it has to be paid within this period of time that straddles the date of entitlement. And there are various exclusions to get around to prevent artificial steps being taken to increase the tax-free amount. The other important condition is that the sum must not be more than the permitted maximum. If it exceeds the permitted maximum, then the excess, only the excess, doesn't count as a pension commencement lump sum. So if too much money is paid by accident, by oversight, or whatever, one still is protected up to the amount of the permitted maximum, and it's only what is beyond that doesn't get the benefits of being a pension commencement lump sum. What's permitted maximum? Well, it's the lower of 3 amounts, or sorry, I should say lowest of 3 amounts. That's a terrible grammatical error for a KC to make, but there it is. I apologize for that. First amount, 1/3 of the value of the money or assets applied at the same time for providing an income. So it's important to focus on exactly what this criterion is. So the person must become entitled to the PCLS in connection with becoming entitled to a pension. This is the income that we're talking about. And one doesn't look at the total value of the fund. One only looks for this for this limit in the permitted maximum at how much of the fund is being earmarked or being used to provide pension income at the same time. This means, of course, for example, that any one pension fund can pay out more than one pension commencement lump sum, provided that it is at different times. Each lump sum is connected to a separate earmarking or purchase of an income from the fund, and the limit of how much can be paid out by lump sum to count as a PCLS is 1/3 of the amount that's used to obtain an income. Second limit is the available lump sum allowance, and I'll just look at that in a minute. And the third is the available lump sum death benefit allowance, which I'll also come back to just shortly. So next slide, what is the available lump sum allowance? This is a new concept, replacing the lifetime allowance, the details of which are set out in the new section 637P of ITIPA 03. So the lump sum allowance is, unlike the lifetime allowance before, it is simply a fixed sum of £268,275. It's an unusual number at first glance, but it equals 1/4 of the lifetime allowance as was up until 5th April of this year. There's no provisions for example, inflationary increases, automatic inflationary increases, as there had been for the lifetime allowance, or as one finds in other allowances throughout the UK tax code. One may suppose that each year the Chancellor will give consideration to whether the amount should be increased or, I dare say, decreased, but the legislation as it stands just provides for this fixed amount, 268,275. That's a starting point in working out the second limit on how much PCLS may be. The second thing that one has to do is to work out how much of that is available. To work out that, one, broadly speaking, has to deduct the non-taxable amount of any previous lump sums received by the recipient of this lump sum. And what's important in that regard is that the non-taxable amount is the amount of a previous lump sum that's been exempt from tax by virtue of Chapter 15A of ITIPA 03. Now, this is the brand new, or replacement rather, chapter in which Section 637P appears and all the other new provisions about lump sums in ITIPA. They go from roughly 637A, I think they get up to 637W. In any event, it's only previous lump sums that are exempt under this chapter that are to be deducted from the lump sum allowance in working out how much can be paid now by pension commencement lump sum. In this context, what is important, one of the things that's important is in relation to clients who have pension schemes also offshore, overseas pension schemes. That's important for clients who've been internationally mobile throughout their careers. The restrictions imposed by the lifetime allowance since A-Day in 1st April 2006 have also made overseas pensions an important means of saving for retirement for higher earning individuals who have been simply UK residents. So there are, of course, a significant number of clients who have not only UK pension schemes, but also overseas pension schemes. QROPs tend to be for people who have been internationally mobile over their careers and therefore needed to rely on migrant member relief to ensure that they get appropriate tax relief for contributions. QNUPs are, of course, a means of protecting pension funds from inheritance tax when one can no longer contribute to a UK fund. They're important because in this context, the taxation of lump sums paid by overseas pension schemes is not set out in Chapter 15A of ITIPA. It is set out, Part 9, it's set out instead of in Chapter 4 of Part 9 of ITIPA. That chapter provides for the taxation of pensions paid by persons outside the UK, which obviously includes trustees or other holders of QROPs and QNUPs to UK residents. Lump sums under these provisions are taxed under sections 574, 574A. So if somebody is not a registered pension scheme and it's not a relevant non-UK scheme, a relevant non-UK scheme is broadly a scheme where contributions are received migrant member relief, or if it's an EFERBS, and lump sum isn't within the disguised remuneration provisions, then a lump sum paid out of it is within the taxing provisions in 574, 574A. A lump sum also is within those provisions if it's from a relevant non-UK scheme. So in other words, again, where contributions have attracted migrant member relief, broadly speaking, and the member payment provisions in Schedule 34 Finance Act 2004 don't apply. So that's the member payment provisions broadly are the provisions that charge unauthorized payments to UK income tax. The type of non-UK schemes that count in this rule, where the recipient of the lump sum is UK resident, at least, are where migrant member relief has been received, or relief for pension contributions has been provided under a double taxation convention. So lump sums paid out of those are within the charge to UK income tax. The amount taxed of a lump sum from a QROPS or a QNUPS is subject to various deductions, including the amount that would be tax-free if it were received under a registered pension scheme. The importance of the way this rule operates is that it's only about calculating the taxable amount of the lump sum. It doesn't confer an exemption from tax, from income tax. And in any event, it's not within Chapter 15A of Part 9. Consequence of this is that where a client has already received a lump sum from a QROPS or a QNUPS, that because of these provisions isn't charged to UK income tax. That overseas lump sum is not deducted from the client's new lump sum allowance in working out whether a lump sum, working out the limit of the amount on which can count as a PCLS under the new rules. So, in other words, it's perfectly possible to receive a lump sum from a QROPS, QNUPS, and still receive a PCLS up to the whole of the lump sum allowance, the 268,275, from a UK registered pension scheme. We'll come to a slightly tricky point in relation to this, or that flows from this in relation to the pension commencement excess lump sum shortly. But for the moment, the point to note is that lump sums that aren't taxed, lump sums from foreign pension schemes that aren't taxed because of the calculation rules in Section 574A are not deducted from the lump sum allowance in working out the limit on a PCLS. The same point applies in relation to the third limit on a PCLS, the lump sum and death benefit allowance. It's fixed by Section 637R, new Section 637R at £1,073,100, which happens to be, of course, 4 times the lump sum allowance 268,275, and is the same as the previous lifetime allowance. In calculating how much of that is available at the time a PCLS is paid, again, one doesn't deduct from that 1,073,000 odd amount the amount of previous lump sums paid out by overseas pension schemes. So that's important in working out how much can be paid by a PCLS now. If one has a lump sum that counts the PCLS, then for income tax purposes, as mentioned, it's already an authorized payment. Therefore, no unauthorized payment charge, no unauthorized payment surcharge, no scheme sanction charge. For normal income tax purposes, as in normal income tax rules in relation to pension income, it's exempt from tax if it's paid out of a registered pension scheme. Broadly the same as has been the case to date. Moving from that then to the second type, the new type of pension commencement lump sum, a pension commencement excess lump sum. As I mentioned at the start, the point is that an excess lump sum remains an authorized payment, which is the consequence that there's no unauthorized payment charge or surcharge, there's no scheme sanction charge. But on the other hand, it is within the normal income tax regime. And will just be taken into account in the normal way as any other pension income would be. Conditions to be met are in the new paragraph 3A in Schedule 29 FA 2004. Some of the same as for the pension commencement lump sum. So first, members get to be entitled to it in connection with becoming entitled to a relevant pension. That's the income element of the pension. It's going to be paid within the period of starting 6 months and ending 1 year after the person becomes entitled to it. So there's a degree to which it can be paid out in advance, or a degree to which it can be delayed, which of course may assist if someone's income is going to drop significantly when he or she retires, and so the marginal tax rate to which he or she is subject will drop, for example, from 45% down to 40%. It may be wise to delay payment of a PCELS or indeed a PCLS until the next tax year. Oh no, PCLS of course doesn't matter. It's exempt from tax, but it may be wise to defer the payment of the excess lump sum to the following year to get a bit lower marginal rate. It's going to be paid at the earliest when the members reach normal minimum retirement age, which of course is ever increasing, or the ill health condition is satisfied. The rules about lump sum allowance in relation to lump sum allowance as to when something counts as an excess lump sum. The rule is that none of the lump sum allowance or lump sum death benefit allowance must be available. In other words, if any part of the lump sum allowance or the lump sum death benefit allowance is available, then anything beyond a PCLS cannot count as a PC excess lump sum. Now, 3 important points to think about here. The legislation first recognizes that a lump sum and an excess lump sum can be paid as a single payment. If a single payment is what's paid out to the pension scheme member, then the legislation treats that payment as using up the lump sum allowance first. That means that that's the benefit of the recipient, because what is an excess lump sum allowance can therefore count as an excess lump sum because the whole lump sum allowance is first used up. However, of course, on the other hand, it may be that there's a gap between the PCLS and the excess lump sum allowance. For example, if the limit on the PCLS in the actual facts of the case is below an individual's lump sum allowance because, for example, there's a lower amount that is 1/3 of the funds that are being used to provide an income at that time, then there may be a shortfall between, on one hand, the lump sum allowance, and on the other hand, the amount that can count as a pension commencement lump sum. What's in the middle between the PCLS of, let's say, £100,000 and the lump sum allowance of 268 can't count as an excess lump sum because some of the lump sum allowance remains available. So that's a trap to watch out for in working out how much can be paid when. The third point, previous payments out of a QROPS, QNUPS, the same outcome applies. Such previous lump sum payments as aren't liable to a UK income tax, and calculating how much can be paid out by way of excess lump sum, these aren't deducted from lump sum allowance, which means, of course, that some of the lump sum allowance or lump sum death benefit allowance may be available. And to that extent, the payment is excluded from counting of the pension commencement excess lump sum and won't therefore on that satisfy that criterion for counting as an authorized payment. So again, there's a risk there's a wee trap that might mean that a payment is an unauthorized payment and attracts the charges that Rebecca was talking about. So that's the rule about the criterion to be satisfied about none of the lump sum allowance, none of the lump sum death benefit allowance be available at the time a payment is made for that payment to count as an excess lump sum and therefore to count as an authorized payment. Various two types of payments are excluded from being an excess lump sum. Number one, if it's already an authorized payment by virtue of the lump sum rule. So, for example, something that counts as a pension commencement lump sum can't be an excess lump sum. Well, that follows anyway from the other criteria that apply. And if it's a lump sum paid under a collective money purchase scheme, drawdown pension, again, it counts an excess lump sum. An important point I mentioned at the start, an important point to emphasize that, of course, all these new rules about PCLSs and PC excess lump sums are just the new rules. They are far exceeded in length by the extensive transitional provisions that have been put in place by FA 24 in relation to existing pension schemes, because there are a number of changes on A-Day, of course, and since then, that mean that existing pensions have to receive certain protections. So anyone who has an existing pension and is taking out a lump sum now will have to look, I'm afraid, at those transitional provisions, and inevitably, the way pension schemes work, will have to do so for a number of years to come. Finally, then on income tax for a PC excess lump sum, it's taxed, I mentioned, just as taxable pension income. New section 637B of ITIPA 03 just brings it within the Part 9 charge in the fairly normal way for any other items of pension income. So at least that's the straightforward part of the new rules. That reaches the end of my talk. I think there may be a couple of questions. I will maybe not. If there are, I will. If there are any questions, happy to take them via the chat function just now. Otherwise, of course, if there are any other questions on either Rebecca's talk or mine, I'm afraid actually Rebecca's had to leave because of a fire alarm in her building. I'm told. Happy to receive any of those by email. I think my email address is on my handout, or otherwise just simply to clarks at 15oldsquare.co.uk. We have one hand up. I'm not sure quite how to.
I've sent a request to unmute, so if Nagas can unmute, that would be great, please.
Yes, if Nagas, if you might just, I think you're able to unmute yourself if you have a question you'd like to ask. Maybe not. Oh, there's a question in the. Is there anything in the new rules which stop double tax relief on cashing a pension in tax-free while non-resident? Off the top of my head, I don't think there is, but as I say, the new rules are so extensive that I couldn't conclusively or definitely say that there is nothing in them that would be relevant to that. And that's one from Michael Evans. And that would certainly require, I think, some research just to check on that. But I don't think that should be a problem. But again, in any specific case, I would recommend looking at the new rules in detail on that issue, and indeed in any other issue to do with taking money out of pensions. Second question from: do the new lump sum allowance rules apply to tax relief funds or registered non-UK scheme by virtue of the member payment provisions if the member is UK resident? I think in effect the answer I think is yes. If so, a non-UK a relevant non-UK scheme that is check to which member payment provisions don't apply. No, so here we've got a question about a scenario in which member payment provisions do apply to a registered non-UK scheme. If the member is UK resident, then the new lump sum allowance rules, I think, do not apply to that. But again, that's something I would have to double check. Next question. If someone dies age 74, having not taken a company pension, what happens to the fund? Company continued to defer as member did not make contact. Pension with defined benefit scheme. Well, that would first point depend on the rules of the particular pension scheme. It may be possible for the fund to be paid out to the members' successors in under succession law or under the member's will. But again, that would also depend on whether the member had given any nomination of a dependent to the pension scheme prior to death. So I think in that question, I can only really say one would have to look in the first place at the pension scheme rules and a bit more closely at any correspondence between right until the wife can receive the pension, only 50% of the fund in those circumstances. So again, what happens to the other 50% depends primarily on, well, in the first place, on the rules. And I think that's about as much as I can realistically say. It is not a straightforward question, which I suppose is why it's arisen. Well, that's just coming up for 2 o'clock. Thank you, everyone, for attending this afternoon. I hope you found this webinar helpful and informative, and hope to see you again, and possibly even in person at one of our in-person chamber seminars over the course of the coming few months. That's all. Thanks. Enjoy your afternoons. Bye for now.